afternoon, ladies and gentlemen. Welcome to County Court at Law number 6 in the Bexar County Veterans Treatment Court. We have a plea docket today, being Thursday, the 18th of March, 2021. And we're going to start off with 3 pleas. First one is 639-445, State of Texas versus Roberto Luna Galvan. 641414, State of Texas versus Efren Kaz Hernandez. And cause 635121, State of Texas versus Jose Enrique Valle. Gentlemen, at this time, I'm going to ask you to identify your signatures on a document for me. In each of these cases, there is a document entitled Defendant's Consent to Plea by Video Conference. Mr. Galvan, is this your signature on this document, sir?
Sí.
And Ms. Benavides, as attorney for Mr. Galvan, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. Mr. Hernandez, is this your signature on this document, sir?
Efraín Hernández.
This is for Efren Hernandez and cause 641414. Mr. Hernandez, is this your signature on the document entitled Defendant's Consent to Plea to Video Conference? And I cannot hear the interpreter. I don't know if she's speaking to us or not.
He's speaking to him.
Okay. If you're not actively speaking with us during these hearings, please turn your microphone off. We're still getting a lot of wind noise from somewhere. Ms. Nero, do I need to repeat the question to you?
Abogado Rodríguez. No.
I can't hear Mr. Hernandez. I don't know if his microphone's on or off. It looks like it's on. Alma, can you jump in here and either speak to Mr. Hernandez or to our interpreter and determine what the answer to that question is? Explain it to them if you would.
Judge, that's not my client. My client is Mr.
Mr. Rodriguez. Excuse me. Daniel, you with us today?
Yes, Judge, this is David Rodriguez. I'm here for Mr. Hernandez. I'm going to message him right now. I don't know why he's having audio issues all of a sudden.
I think they're having.
Your Honor, and I think it's Mr. Hernandez's phone that you're hearing the wind and everything because he's outside, I think.
No escucho el intérprete.
Yeah.
Mr. Rodriguez, would you like me to repeat the question to Mr. Hernandez?
Yeah.
Mr. Rodriguez, are you able to speak to your client at this time?
Judge, I'm trying to text him, but I can give him a call, Judge.
Okay, why don't you try that, please?
Okay.
Okay, while they're trying to get some commo, let's go ahead and continue our pleas on 639-445, State of Texas versus Roberto Luna Galvan, and 635-121, State of Texas versus Jose Enriquez Valle, represented by Mr. Juan Elizondo. Mr. Valle, is this your signature on the document entitled Defendant's Consent to Plea by Video Conference?
Yes.
Thank you. And Mr. Elizondo, as attorney for Mr. Valle, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. Mr. Luna Galvan and Mr. Valle, I'm now looking at a document entitled Defendant's Waiver of Constitutional Rights and Court's Admonition that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Luna Galvan, is this your signature on this document, sir?
Sí, es mi firma.
Ms. Benavides, can you tell if we have a yes or a no answer on that question?
It's a yes, Your Honor.
Okay, thank you. Ms. Benavides, as attorney for Mr. Luna Galvan, is this your signature on this document, ma'am?
Yes, it is, Your Honor.
And Mr. Valle, is this your signature on this document, sir?
Yes, sir.
And actually, as attorney for Mr. Valle, is this your signature on this document, Mr. Elizondo?
Yes, Your Honor.
By signing this document, Mr. Luna Galvan and Mr. Valle, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, so that in signing these documents, you're telling me that you agree with and understand everything on this document. Is that correct, Mr. Galvan?
Sí, es correcto.
Thank you. And is that correct, Mr. Valle?
Yes.
As attorney for Mr. Luna Galvan, have you had enough time to go over this case with him? And in your opinion, is he mentally competent? Ms. Benavides.
Yes, Your Honor.
The same question for Mr. Elizondo as attorney for Mr. Valle.
Yes, Your Honor.
Mr. Luna Galvan, are you a United States citizen, sir?
No,
Mr. Luna Galvan, excuse me, Mr. Valle, are you a United States citizen, sir?
No, sir.
Is that yes? No.
No.
Okay. Both Mr. Luna Galvan and Mr. Valle, if you are not citizens of the United States of America, a plea of guilty or nolo contendere for the offense charged may result in your deportation, your exclusion from admission to this country, or the denial of naturalization under federal law. Mr. Luna Galvan and Mr. Valle, have you discussed with your attorneys and been made aware of the mentioned consequences? And are you still knowingly now wanting to plead to this offense? Mr. Luna Galvan first. What is your answer, sir?
sí,
Would that be yes, Ms. Benavides?
That's a yes, Your Honor.
Thank you. And Mr. Valle, your answer to this question, sir.
Yes, sir.
Thank you. As attorney for Mr. Luna Galvan, have you had the ability to discuss with him the possible problems he may encounter with regard to his immigration status if he enters a plea to this crime? Ms. Benavides.
Yes, Your Honor, I have.
And after your discussion with him, did he indicate to you he still wanted to go forward with a plea bargain with the state?
Yeah.
Yes, he did, Your Honor. And he spoke with an immigration attorney who has given him the go-ahead to enter into this plea.
Thank you. Same question for Mr. Elizondo. Have you had the ability to discuss with your client the problems he may encounter with regard to his immigration status if he enters a plea to this crime?
Yes, Your Honor.
And after your discussion with him, did he indicate to you he still wanted to go forward with a plea bargain with the state?
Yes, Your Honor.
Was that yes? I'm sorry, I missed it.
Yes, Your Honor.
Oh, thank you. Okay. Ms. Benavides, has the state fully complied with discovery for you on this case?
Yes, they have, Your Honor.
Same question for Mr. Elizondo.
Yes, Your Honor.
And for the record, on both case 639-445, State of Texas versus Roberto Luna Galvan, and 635-121, State of Texas versus Jose Enrique Valle. We have all these documents entitled Defendant's Waiver of Constitutional Rights and Court's Admonition in English and in Spanish on each case. And we have the document entitled Trial Court Certification of Defendant's Right of Appeal in English and in Spanish on each case for the defendant. Mr. Galvan, in cause 639-445. Rather, state you have a motion at this time. Do you not, state?
Correct, Judge. The state moves to add a count 2 of obstruction, waive count 1, and proceed on count 2.
Objection from the defense, that will be granted. At this time, Mr. Luna Galvan, to the charge of obstruction of a highway, how do you plead, sir?
Culpable.
That'd be guilty, Elma?
Yes, Your Honor.
Okay. State, is there an agreement in this case?
6/11, $500 fine, court costs, 48 hours community service, DWI education, DIP, CAD SNP, and Smart Start Mobile for half the term.
And
And Your Honor, that is our agreement. And just to let the court know, Mr. Galvan has had the Smart Start Mobile since June 16th of 2020.
okay, and he's blowing 4 times a day, hopefully.
I don't know how many times per day.
Would you mind asking him?
Pues normalmente entre 3, 4 veces.
Do we know how many times a day Mr. Luna Galvan is blowing in the Smart Start machine?
It's 3 to 4 times, Your Honor.
All right, it's supposed to be 4, so we'll make sure it's 4 for him. Okay, make sure I get this correctly. Mr. Luna Galvan, the court accepts your plea of guilty to the offense of obstruction of a highway. I find you guilty. I assess 6 months in the Bexar County Jail, probated for 11 months. A $500 fine plus court cost, 48 hours community service, DWI education course, DWI Victim Impact Panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, and a Smart Start mobile device for 5.5 months at 4 blows a day. What did I miss, Ms. Benavides?
Your Honor, I think that's it. I just wanted to make sure that he's clear about whether he's going to call probation or if they're going to be calling him.
Pat, can you clarify what probation status is on how they're going to contact our defendants? And your microphone is still.
Yes, sir. Your Honor, they will contact him within 48 hours. If they do not contact him within 48 hours, he needs to call the probation department. And this is for everybody who is getting probation. You have 48 hours. If they don't call, the phone number is 210-335-7200 and ask for intake. It will be your responsibility to call if they have not contacted you within 48 hours.
Okay, Ms. O'Connor, back on 639-445, State of Texas versus Roberto Luna Galvan. Did I accurately state the plea bargain from your understanding?
I just want to make sure you said 6/11, correct, Judge?
That's what I got, 6 months over 11 months, correct?
Correct.
All right, then we're good. Anything further from the state or the defense on Mr. Galvan?
Nothing further, Your Honor. May we be excused?
Yes, thanks, Ms. Benavides. Thank you, Mr. Galvan. Good luck.
Thank you.
Okay.
Ok, muchas gracias.
Mr. Valle, to the charge of reckless driving, how do you plead, sir?
Been no context.
Court accepts the plea of no contest to the charge of reckless driving. Is there an agreement for Mr. Valle?
6 months deferred adjudication, $200 fine, court costs, 24 hours community service, and a driver safety course.
And defense, is that your understanding of the agreement?
Yes, it is, Your Honor.
Mr. Valle, the court accepts your plea of no contest to the offense of reckless driving. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 6 months, deferred adjudication probation. It says a $200 fine plus court costs, 24 hours community service, and the Community Alliance for Traffic Safety driver safety course, which they call their aggressive driving course. Anything further from the state of the defense on Mr. Valle?
Nothing from the defense, Your Honor.
Good luck, Mr. Valle.
May we be excused, Your Honor?
You bet. Thank you very much.
Thank you, Your Honor.
Pat, do we have a current status on Mr. Hernandez as far as communication goes?
Yes, I'm here right here, Your Honor.
Were you able?
No, that would be Johnny Hernandez, Your Honor. Efren Hernandez.
This is Efren Hernandez, who had the communication problem with us a moment ago during the plea. Daniel Rodriguez with us at this time?
Judge, I'm here for defendant Efren Hernandez.
Were you able to get communication with him?
I communicated with the judge and he's on. I don't know if the interpreter is able to communicate with him now or not.
Can our interpreter see if she can get in contact with Mr. Efren Kaz Hernandez at this time?
She's trying, Your Honor.
I'm sorry?
She's trying right now, I believe.
Okay, great. Thank you.
And Judge, if it doesn't work, I don't know. I can bring him into my office to make sure we don't have these issues.
Yeah,
forward. I don't know.
at some future point, we might need to do that. Pat, do you have an idea when we get to do that with the point of least resistance?
Monday, we're going to need an interpreter at that time. You could bring him in on Monday.
Okay, and what time is that?
It would be at 2
2?
o'clock. Yeah.
Monday at 2? Okay, I'm
Yeah.
available Monday at 2. I'll just have him here in my office so I'll make sure we don't have all these issues.
Okay.
That'd be great. Thank you.
Okay,
Okay.
all right, thank you.
Yeah, Monday at 2. That'd be easier. I'll need one anyway. Okay?
Okay, all right, thank you.
Thank you. No, that's it. We took care of him. Thank you.
All right, thank you.
Okay, Judge.
I'm working it. Okay, at this time, we're going to take up cause number 629833, State of Texas versus David Martinez Jr., 654202, State of Texas versus Amanda Romo, cause 633662, State of Texas versus Joel Islas Lopez, cause 636398, State of Texas versus Rafael Garcia, cause number 633223, State of Texas versus Steve Aleman, and cause 651436, State of Texas versus Sean Montgomery. Representing Mr. Martinez is Mr. Chris Gober. Chris, are you with us today?
Yes, Your Honor, and so is Mr. Martinez.
And Mr. Vela, representing Ms. Romo, are you with us today?
Yes, Your Honor.
Thank you. Mr. Arguelles, representing Mr. Lopez, are you with us today, sir?
Yes, Your Honor, I'm present for Mr. Lopez.
And representing Mr. Garcia, Mr. Thomas Placier. Mr. Placier, are you with us today?
I am, Your Honor. He's here with me, Judge.
Thank you. And Mr. Lambert, representing Mr. Aleman, are you with us today, Mr. Lambert?
I'm here, Your Honor.
Thank you, sir. And Mr. Andrews, representing Ms. Montgomery, are you here with us today, sir?
I am, Your Honor.
Thank you, sir. Okay. Defendants, in these cause numbers, I am first going to ask you to identify your signature on a document entitled Defendant's Consent to Plea by Video Conference. In cause 629833, Mr. Martinez, is this your signature on this document, sir?
Yes, it is, Your Honor.
Thank you. And Mr. Gober, as attorney for Mr. Martinez, is this your signature on this document?
It
sir?
is, Your Honor.
Thank you. In clause 654202, Ms. Romo, is this your signature on this document, ma'am? Can we hear Ms. Romo?
Yes, it's my signature. Mhm.
Can you hear us, Ms. Romo?
Yeah, I can hear you.
All right, is this your signature on this document, ma'am?
Yes, it is.
Thank you so much. And Mr. Vela, as attorney for Ms. Romo, is this your signature on the document, sir?
Yes, Your Honor.
And Mr. Lopez, is this your signature on this document in clause 633662?
Mr. Lopez, can you unmute yourself, please?
Yes, Your Honor. Thank you. And Mr. Arguelles, as attorney for Mr. Lopez, is this your signature on this document, sir?
It is, Your Honor.
Thank you. Mr. Garcia, in clause 636398, is this your signature on this document, sir?
Yes, it is, Your Honor.
And Mr. Placer, as attorney for Mr. Garcia, is this also your signature on this document?
It is, Your Honor.
Thank you. Mr. Aleman, in clause 633223, is this your signature on this document, sir?
You're muted, Mr. Alaman.
Can you hear me, Mr. Aleman?
You'll have to unmute it and then mute back whenever you.
Someone's talking to me, but I don't know.
Okay, yes, I was muted from the host. Yes, I'm here. This is Steve Aleman.
Okay, thank you. And Mr. Lambert, is this your signature as attorney for Mr. Aleman on this document?
It is, Your Honor.
And is it Mr. Montgomery? Is that correct?
Yes, Your Honor.
Mr. Montgomery, is this your signature on this document with a cause number of 651436?
Yes, sir.
Mr. Anders, as attorney for Mr. Montgomery, is this your signature also on this document?
It is, Your Honor.
Thank you. All defendants, the next document I'm looking at.
It's like leggings and like top.
The next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's admonitions that purports to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Martinez, is this your signature on this document, sir?
Yes, it is, Your Honor.
Thank you. Mr. Romo, is this your signature on this document, sir? Ms. Romo, I'm sorry. Can you hear me?
Your Honor, if I might interrupt, I'm a counsel for Mr. Martinez, and that is my signature on that.
All right. Thank you. Ms. Romo, can you hear me, ma'am?
Yes, I can.
And I apologize, we're having a hard time doing this. Is this your signature on this document?
Yes, it is.
Thank you. In clause 633662, Mr. Lopez, is this your signature on the document, sir?
Mr. Lopez, can you unmute yourself again?
Mr. Lopez, can you hear me, sir?
Yes, sir.
All right, thank you, sir. And in clause 636398, Mr. Garcia, is this your signature on this document?
Yes, Your Honor.
Thank you. Mr. Aleman, in clause 633223, is this your signature on this document?
Yes, Your Honor.
Thank you. And in clause 651436, Mr. Montgomery, is this your signature on this document?
Yes, sir.
Thank you. By signing this document, are each of you telling me that you've had enough time to either read this document or have it read to you in their entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, so that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Martinez?
Yes, Your Honor.
Thank you. Is that correct, Ms. Romo?
Yes,
Thank you. Is that correct, Mr. Lopez?
Yes, Your Honor.
Thank you. Is that correct, Mr. Garcia?
Yes, Your Honor.
Thank you. Is that correct, Mr. Aleman?
Yes, Your Honor.
Thank you. Is that correct, Mr. Montgomery?
Yes, sir.
Thank you. As attorney for Mr. Martinez, have you had enough time to go over this case with him? And in your opinion, is he mentally competent? Mr. Gover?
Yes, Your Honor.
Same question for attorney for Ms. Romo.
Yes, Your Honor.
Same question for attorney for Mr. Lopez. Mr. Arguelles?
Yes, Your Honor.
Thank you. Same question for attorney for Mr. Garcia.
He is, Your Honor.
Same question for attorney for Mr. Aleman.
Affirmative, Your Honor.
Thank you. Same question for attorney for Mr. Montgomery.
Yes, Your Honor.
Thank you. Mr. Gover, as attorney for Mr. Martinez, has the state fully complied with discovery for you on this case?
State has, Your Honor.
Thank you. Same question for attorney for Ms. Romo. Mr. Vela?
Yes, Your Honor.
Thank you. Same question for attorney for Mr. Lopez. Mr. Arguelles?
Yes, Your Honor.
Thank you. Same question for attorney for Mr. Garcia. Mr. Plessia?
They have, Your Honor.
Thank you. Same question for attorney for Mr. Alemán, Mr. Lambert.
Yes, Your Honor.
Thank you. Same question for attorney for Mr. Montgomery, Mr. Anders.
Yes, Your Honor.
Mr. Martinez, are you a United States citizen, sir?
Yes, sir.
Thank you. Same question for Ms. Romo.
Yes.
Thank you. Same question for Mr. Lopez.
No, sir.
Is that yes?
No, sir.
No.
No. Thank you. Stand by. Same question for Mr. Garcia.
Yes.
Same question for Mr. Alemán.
Yes, sir.
And same question for Mr. Montgomery.
Yes, sir.
Lopez, if you are not a citizen of the United States of America, a plea of guilty or nolo contendere for the offense charged may result in your deportation, your exclusion from admission to this country, or the denial of naturalization under federal law. Mr. Lopez, have you discussed with your attorney and been made aware of the mentioned consequences? And are you still knowingly wanting to enter a plea to this offense?
Yes, sir.
Thank you. Mr. Arguelles, as attorney for Mr. Lopez, have you had the ability to talk to him about the possible problems he may encounter with regard to his immigration status if he enters a plea to this crime?
That is correct, Your Honor, and he has conferred with his immigration lawyer.
After your discussion with him, did he indicate to you that he wanted to go forward with a plea bargain with the state at this time?
Correct, Judge.
Thank you. And let's see, Mr. Gober, does the state fully comply with discovery for you on Mr. Martinez's case?
Yes, Your Honor.
Same question for Mr. Vela with regard to Ms. Romo's case.
Yes, Your Honor.
Same question for Mr. Arguelles with regard to Mr. Lopez's case.
Yes, Your Honor.
Same question for Mr. Placier with regard to Mr. Garcia's case.
Yes, Your Honor.
Same question for Mr. Lambert with regard to Mr. Alemán's case.
Yes, Your Honor.
And same question for Mr. Anders with regard to Mr. Montgomery's case.
Yes, Your Honor.
Thank you. Okay, state and cause 629833, State of Texas versus David Martinez Jr. Starting out, I guess, as a DWI greater than 0.15, and apparently you have a motion. Is that correct?
Correct, Judge. The state moves to add a count 2 of obstruction, waive count 1, and proceed on count 2.
No objection from the defense. That will be granted. So at this point in time, we're going forward on paragraph 2, which is obstruction of a highway. Is that your understanding, State?
Correct.
Okay. Mr. Martinez, to the charge of obstruction of a highway, how do you plead, sir?
No contest.
And is there an agreement for Mr. Martinez?
6/16, an $840 fine, $60 to DPS, court costs, 36 hours community service, DWI education, DIP, CAD SNP, and Smart Start Mobile for half the term.
I guess that's correct.
And defense, is that your understanding of the agreement?
That is my understanding.
Mr. Martinez, the court accepts your plea of no contest in defense of obstruction of a highway. I find you guilty. I said 6 months in the Bexar County Jail, probated for 16 months, an $840 fine, plus court costs, plus $60 to the Texas Department of Public Safety for, I assume, a lab fee. 36 hours of community service, DWI education, DWI Victim Impact Panel, Community Alliance for Traffic Safety New Intervention Program, and Smart Start Mobile for 1/2 the term, which is going to be 8 months. Anything further from the state or the defense on Mr. Martinez?
Yes, Your Honor.
Sure.
Your Honor?
Yep.
The paperwork reflects an $850 fine, and I think the representation from Ms. O'Connor was $840. I don't want to get persnickety, but there's that $10 difference.
Ms. O'Connor, you want to leave it $840 or $850? Your call.
$840, Judge.
All right, we just saved everybody $10. Thank you, state. How kind. All right, anything further from the state or the defense on Mr. Martinez?
No, Your Honor.
And Mr. Martinez, you understand what's going on with the probation department? If you don't get a call from them, you got to call them back.
Yes, sir.
All right, thank you, sir. Good luck. Thanks, Chris.
Thank you, Your Honor.
Okay, 654-202, State of Texas versus Amanda Romo. And Ms. Romo to the charge of graffiti, $100 to $750. How do you plead, ma'am?
No contest.
Is there an agreement from Ms. Romo?
1 day in the Bexar County Jail, $300 fine, court costs, credit for time served, time and money to run concurrent, and we ask this be a JSAT, Judge.
Defense, is that your understanding of the agreement?
Yes, Your Honor.
I don't want to be a speed bump in the road, but on these graffiti cases, are we sure there's no restitution that's going to become a problem for somebody eventually?
I double checked, Judge. There's
All
no
right.
restitution.
We're good on that. Then we're excellent. Good. All right, Ms. Romo, the court accepts your plea of no contest to the charge of graffiti, $100 to $750. I find you guilty. I said 1 day in the Bexar County Jail, a $300 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state of the defense on Ms. Romo?
No, Your Honor.
Thank you, Mr. Vela. Thank you, Ms. Romo.
Thank you.
Thank you.
Order dismissed.
Yes, sir.
Mr. Lopez, in clause 633-662, to the charge of driving while intoxicated with a blood or breath alcohol content of 0.15 or higher. How do you plead, sir?
Yes.
Guilty, is that correct?
Guilty.
Is there an agreement with this case, state?
6/12, $500 fine, court costs, 48 hours community service, DWI education, DIP, CAT SNP, Smart Start Mobile for half the term, and restitution, if any, to Rosalina de Alvarez.
Mr. Arguelles, is that your understanding of the agreement?
That's correct, Your Honor.
Mr. Lopez, the court accepts your plea of guilty to the offense of driving while intoxicated with a blood or breath alcohol content of 0.15 or higher. I find you guilty. I said 6 months in the Bexar County Jail, probated for 1 year. A $500 fine plus court costs, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, Smart Start Mobile, home interlock for 6 months, and for you to pay restitution, if any, to Rosalina de Alvarez. Anything further from the state of the defense on Mr. Lopez?
Nothing further from the defense, Judge.
Good luck, Mr. Lopez. Thank you,
May
Mr. Lopez.
may we be excused, Judge?
You bet.
Mr. Lopez, you can sign off now. Thank you, Judge.
Thank you. Mr. Garcia. In clause 636 and 398 to the charge of driving while intoxicated. How do you plead, sir?
No contest, sir.
Is there an agreement for Mr. Garcia?
6/12, $500 fine, court costs, 48 hours community service, DWI education, DIP, CAT SNP, and Smart Start Mobile for half the term.
And defense, is that your understanding of the agreement?
That is our agreement, Your Honor.
Mr. Garcia, the court accepts your plea of no contest to the offense of driving while intoxicated, first offense. I find you guilty. I said 6 months in the Bexar County Jail, probated for 1 year, a $500 fine plus court costs, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, and Smart Start Mobile home interlock for 6 months. Anything further from the state of the defense on Mr. Garcia?
Your Honor, Mr. Garcia is interested in buying out community service hours. Will he contact the court in regards to that?
Yeah, I apologize. I'm having a hard time understanding what you're saying. Say that again, please.
Mr. Garcia is interested in buying out his community service hours, Your Honor.
But we don't call it buying out. He can donate $10 an hour to a court charity for community service hours and get credit for that, and that's not a problem.
Okay, thank you, Your Honor.
Okay. Good luck, Mr. Garcia. Thank you.
Thank you, Your Honor.
Class 633-223. Mr. Aleman to the charge of driving while intoxicated, second offense. How do you plead, sir?
Mr. Elman, I believe you're still muted.
And once again, I'm having a hard time understanding. Did Mr. Aleman enter a plea on this case yet?
Not yet, Your Honor. He's still muted.
Oh, you muted. I'm sorry.
He's saying he's muted by the host.
Okay, there it goes.
There you are. Mr. Aleman, can you hear us? Mr. Aleman?
Yes, I'm here. I'm sorry. I'm here.
To the charge of driving while intoxicated, second offense. How do you plead, sir?
No contest, sir.
Okay, our paperwork says guilty, and I don't really care one way or the other, and I doubt the state does. Defense, how do you want to do it? Guilty or no
I
contest?
believe we had, to get the plea, we had to plead guilty to it, Your Honor.
Okay. So is that okay with you, Mr. Alamán? I'll accept the plea of guilty to the offense of driving while intoxicated, second offense. Apparently that's
Yes,
part
sir.
of your bargain.
Yes, sir.
All right, state, is there an agreement in this case, please?
1/18, $400 fine, plus court costs, 36 hours community service, DWI intervention, DIP, CAD SNP, Smart Start Mobile for half the term, and restitution, if any, to Fidel Flores Jr.
Is that your understanding of the agreement, Mr. Lambert?
That is, Your Honor.
Mr. Alamán, the court accepts your plea of guilty to the offense of driving while intoxicated, second offense. I find you guilty. I assess 1 year in the Bexar County Jail, probated for 18 months. A $400 fine plus court cost, 36 hours community service. DWI intervention program, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, Smart Start Mobile, home interlock for 9 months, and restitution, if any, to Fidel Flores Jr. Anything further from the state of the defense on Mr. Alamán?
Your Honor, one question in regards to restitution. Will probation reach out to him if restitution is found out and he has to pay it?
My understanding is probation will just out of the blue, if there's restitution due according to probation and their investigation,
Okay.
say you owe $2.5 million, at which point you will request a restitution hearing, and the state and the defense and I will have a restitution hearing at that point. If it's
Understood,
something
Your
y'all
Honor.
agree with, then y'all just pay it and we all move along. But hopefully you got insurance and that'll take care of it.
Understood, Your Honor.
Will that answer your question?
Yes, it does, Your Honor. Nothing else
All
from
right.
the defense.
Thanks, Mr. Lambert. Good luck, Mr. Alamán.
Thank you very much, Your Honor.
Okay, Mr. Montgomery, in clause 651-436, to the charge of driving while intoxicated, first offense. How do you plead, sir?
No contest.
And state, is there an agreement in this case?
6/12, $500 fine, court costs, DWI education, DIP, CAD SNP, Smart Start Mobile for half the term, and we're gonna go open on restitution, Judge. The state's recommendation is just restitution, if any, to Jose Hernandez.
Let me ask both sides the question. I assume there's an accident in this case. Is that correct?
Correct.
And defense, it's your position that there won't be any restitution. Is that correct?
No, Your Honor. My position is that that restitution is to be determined at the time of sentencing, and if not, then a hearing is to be set for the determination of restitution.
Okay. Mr. Montgomery, the court accepts your plea of no contest, defense of driving while intoxicated, first offense. I find you guilty. I said 6 months in the Bexar County Jail, probated for 1 year, a $500 fine plus court cost. DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, Smart Start Mobile, home interlock for 6 months. And you are ordered in the nicest possible way to pay restitution, if any, to Jose Hernandez. Now, having said that, once again, we can have a restitution hearing if that becomes necessary. Hopefully the insurance companies can fight that out and we won't have to worry about that. Defense, is that equitable to you?
Actually, no, Your Honor. I think that a restitution hearing should be, if it's going to not be determined today, because then a restitution hearing should be set in the next week, 2 weeks, 3 weeks. The ADA has indicated that she has attempted to get hold of the person and the person has not responded. So my request is that whatever evidence that they have of that should be brought before the court in short order.
Okay. Well, at this point in time, like the other 2.5 million cases we've done in the last 20 years, I'm going to order a restitution, if any, and tell you right now that you're entitled to a hearing anytime you want one. And if you want to come in and prove that your client was not the proximate cause of the accident and therefore shouldn't pay any restitution, you're welcome to do that at the appropriate time. I understand your position, but I'm not going along with it. It came open to me and that's my ruling. Any other questions about that?
No, sir. I just have law that supports my position. So if at some point in time you'd like to see that, then I'm open to giving that to you if you wish.
Sure. You're welcome to provide law to me and to the state anytime.
Okay. So I can make my restitution hearing appointment with Pat and as soon as we're done with this.
Correct.
Okay. Thank you, Your Honor.
You bet. Anything further from the state or the defense on Mr. Montgomery?
No, Your Honor.
All right. Good luck, Mr. Montgomery. Thank you, Mr. Andrews. Water break. Okay, at this point, I've got cause 639-347, State of Texas versus Paulino Roman Cisneros. Cause 624419, State of Texas versus Gregory J. Allison. Cause 631331, State of Texas versus Silvano Villalobos. Cause number 648298, State of Texas versus Christian O. Banegas Orendane. And 635493, State of Texas versus Matthew V. Grimm. And 644082, State of Texas versus Dustin Deaton. Initially, I need each of you to identify your signature for me. Each of these cases has a document entitled Defendant's Consent to Plea by Video Conference. On cause 639347, Mr. Cisneros, is your signature on this document?
Yes, sir.
Thank you. And as attorney, Mr. Cisneros, Mr. DeWalt, is this your signature on this document?
Yes, it is, Your Honor.
Thank you. In cause 624419, State of Texas versus Gregory J. Allison. Mr. Allison, is this your signature on this document, sir? Mr. Allison, can you hear me?
Yes, sir. Sorry.
Thank you, not a problem. And Mr. Mulliner, as attorney for Mr. Allison, is this your signature on this document, sir?
Yes, sir.
Thank you. Mr. Villalobos, is this your signature on this document in clause 631331?
Yes, sir.
Thank you. And Ms. Zabel, as attorney for Mr. Villalobos, is this your signature on this document, ma'am?
It is, Your Honor.
Thank you. In clause 648298, Mr. Banegas Orendane, is this your signature on this document, sir?
Yes, sir.
And Mr. Lopez, as attorney for Mr. Banegas Orendane, is this your signature on this document, sir?
It is, Your Honor.
Thank you. In clause 635493, Mr. Grimm, is this your signature on this document?
Yes, Your Honor.
And Mr. Lopez, as attorney for Mr. Grimm, is this your signature on this document, sir?
Yes, Your Honor.
And thank you. In clause 644082, Mr. Deaton, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Hernandez, as attorney for Mr. Deaton, is this your signature also on this document?
Yes, Your Honor, it is.
The next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purports to have each of your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Cisneros, is this your signature on this document, sir?
Yes, sir.
Thank you. Mr. Allison, is this your signature on this document, sir?
Yes, sir.
Thank you. Mr. Villalobos, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. Mr. Banegas Orendane, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. Mr. Grimm, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Mr. Deaton, is this your signature on this document, sir?
Yes, sir.
Thank you. By signing these documents, are each of you telling me that you've had enough time to either read these documents or have them read to you in their entirety? If you had any questions about what was on these documents, those questions were answered to your satisfaction by your attorneys. So in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Cisneros?
Yes, sir.
Thank you. Is that correct, Mr. Allison?
Yes, sir.
Thank you. Is that correct, Mr. Villalobos?
Yes, Your Honor.
Thank you. Is that correct, Mr. Banegas Orendane?
Yes, Your Honor.
Thank you. Is that correct, Mr. Grimm?
Yes, Your Honor.
Thank you. And is that correct, Mr. Deaton?
Yes, sir.
Thank you. As attorney for Mr. Cisneros, have you had enough time to go over this case with him? And in your opinion, is he mentally competent? Mr. DeWalt?
Yes, sir.
Thank you. Same question for Mr. Mulliner, as attorney for Mr. Allison.
Yes, Judge.
Thank you. Same question for Ms. Zabel, as attorney for Mr. Villalobos.
He is, Your Honor.
Thank you. Same question for Mr. Lopez, as attorney for Mr. Banegas Orendane.
Yes, Your Honor.
Thank you. Same question for Mr. Lopez, as attorney for Mr. Grimm.
Yes, Your Honor.
Thank you. And same question for Mr. Hernandez as attorney for Mr. Deaton.
Yes, in my opinion, yes, Your Honor.
Thank you. Mr. Cisneros, are you a United States citizen, sir?
Yes, sir.
Thank you. Same question for Mr. Allison.
Yes, sir.
Thank you. Same question for Mr. Villalobos.
Yes, Your Honor.
Thank you. Same question for Mr. Venegas Ornday.
Yes, Your Honor.
Thank you. Same question for Mr. Grimm.
Yes, Your Honor.
Thank you. Same question for Mr. Deaton.
Yes, sir.
Is that yes, correct, Mr. Deaton?
Yes.
Thank you. Mr. DeWalt, as attorney for Mr. Cisneros, has the state fully complied with discovery for you on this case?
I believe they have, Your Honor.
Thank you. Same question for Mr. Mulliner as attorney for Mr. Allison.
Yes, Your Honor.
Thank you. Same question for Mr. Bell as attorney for Mr. Villalobos.
They have, Your Honor.
Same question for Mr. Ray Lopez as attorney for Mr. Venegas Orndain.
Yes, Your Honor.
Thank you. Same question for Mr. Brandon Lopez as attorney for Mr. Grimm.
Yes, Your Honor.
And same question for Mr. Hernandez as attorney for Mr. Deaton.
I believe so, Your Honor.
Thank you. Okay, Mr. Cisneros, in clause 639347, to the charge of driving while intoxicated, second offense, how do you plead, sir?
No contest.
Court accepts the plea of no contest, the offense of driving while intoxicated, second offense. State, is there an agreement in this case?
1/1, $400 fine, court costs, 36 hours community service, DWI intervention, DIP, CAT SNP, drug offender education program, and Smart Start Mobile for half the term.
Mr. DeWalt, is that your understanding of the agreement?
It is, Your Honor.
Mr. Cisneros, the court accepts your plea of no contest to the offense of driving while intoxicated, second offense. I find you guilty. I assess 1 year in the Bear County Jail, probated for 1 year, a $400 fine plus court costs, 36 hours community service, DWI intervention program, DWI victim impact panel, Community Alliance for Traffic Safety new intervention program, outpatient drug, DOEP course, and Smart Start Mobile home interlock for 6 months. Anything further from the state of the defense from Mr. Cisneros?
Nothing from defense, Your Honor.
Yeah, good luck, Mr. Cisneros. Thank you, Mr. DeWalt.
Your Honor, if I may, will probation be getting in contact with them, or does he call them?
My understanding, go ahead, Pat, are you with us?
Yes, Mr. DeWalt, they will contact your client within 48 hours. If they do not contact him within 48 hours, he needs to call the probation department. The number is 10-335-7220 and ask for intake. And it is his responsibility, if he has not heard from them within 48 hours, he needs to call, or else there will be a warrant for his arrest.
Thank you, Pat. Very
You're
informative.
welcome.
Judge, can we be excused?
You bet. Thank you very much.
Thank you much.
Okay. 624419, Mr. Allison. Let me see what we're doing.
Yes, sir.
State, you got a motion on this case, apparently.
Judge, there's more to this case. So the state's position is that the defendant was supposed to complete some classes, and then we were going to do 7 days full GPS house arrest. But I was informed today that the defendant did not complete the classes, so that we could not plead the case out today.
Mr. Mulliner, was this supposed to be a JSAT type circumstance, or what is it that the defense was looking for?
Yeah, there was never a thought that he was going to do the classes in advance. In a nutshell, here's what the understanding was going to be. He gets reduced from a second to a first. He gets a judgment satisfied after he has 1 week in jail. He only has 1 day credit. So he has 6 days left to go. The state wouldn't object if you let him serve his final 6 days on GPS house arrest. The state also requires, and we accept, that he needs to do DIP, DWI intervention, and CAT SNP in order for the deal to go through. And so there's only 2 ways to do it. as we sit here today. One is we could reset it till the classes are done, but the fly in that ointment is the classes don't want him to sign up unless he has an order from probation or somebody. Or the other way to do it is to just hold his sentencing in abeyance until he proves I did cat, snip, dip, and DWI intervention. And the court's going to want the Smart Start until he's done with everything while he's still under your jurisdiction. So he stays on Smart Start till he finishes all the classes. The longest class is DWI intervention. That's 6 weeks. He's going to need, if the court gives him house arrest, he's going to need a GPS monitor for those 6 weeks. So my thought was give him 7 days, Bear County Jail, credit for the 1 day time served, require him to do 6 more days on GPS house arrest, order that he do DWI intervention, cat, snip, and dip, and hold sentencing in abeyance for 7 weeks, because intervention takes 6, and we come back and prove he's done all the stuff, and then you can just push the sentence through. That's what I was thinking. Or if you want to just reset it, or
I thought I'd seen it all.
Your mind, because I just talked too long. Whatever you want.
Let me ask you this:
what?
How much longer does Mr. Allison anticipate it's going to take him to finish DWI intervention, the Victim Impact Panel, and the Community Alliance for Traffic Safety New Intervention Program? I mean, is he in the middle of them, or has he started them yet, or what's our status on those?
They won't let him start them until he has an order to get into it, which would need to come from probation or somebody. He's going to do it right away. So if it's 6 week class, he'll be done in 7 weeks. He just wants to knock it out because he knows this case is over when he's done. He just wants to knock him out, and he will.
What do you think about? I don't like leaving things undone, which we would be pretty much effectively doing in this case. I understand what the defense was trying to do. We just couldn't get it done. What does both sides think about the possibility of coming up with a specific time? And I'm thinking 6 weeks, 8 weeks, something. I think that's all it's going to take him to finish these required courses that the state wants, and put him on partial GPS, which is going to replace 6 more days of full GPS or whatever in everybody's mind, to be an equivalent or something. And then basically he's on probation for 2 months and gets this stuff finished. If he doesn't get it finished, they file an MTR on it. I mean, that's something that would be, he could do.
It's a conviction. Yes, it's a conviction either way. So put him on 2 months of probation with these conditions. And if he doesn't complete them within 2 months, then file an MTR. It does the same thing from my perspective.
State, is that something you feel like would work for you?
State?
Yes, Judge.
Okay. Hey, Mr. Allison, here's what we're trying to do. And I don't want to set you up for failure. So I think that the Community Alliance for Traffic Safety New Intervention Program, I think it's 2 hours a week for 6 weeks is what I think it is. Pat, do you recall specifically what the requirements are for that? The outpatient drug course?
I'm not sure whether it's 6 weeks or 8 weeks, Your Honor. 2 hours.
It's no more than 8 weeks. I'm guessing it's 6.
Yes.
The DWI intervention course, that's probably 6 weeks to 8 weeks also, do we not think?
Normally it's 30 something hours, and they do 2 hours 2 times a week normally.
The Victim Impact Panel is 2 hours after you get there. So, I mean, that one's going to be a no-brainer. All right, let me state this the best I can, and then both the state and defense jump in, and we'll craft it from there. Mr. Allison, the court accepts your plea of no contest to the crime of driving while intoxicated first offense. I find you guilty. I sentence you to 6 months in the Bear County Jail, probated for 2 months. Jeff, does that sound right?
Yes, sir.
Okay. Requiring you to complete the DWI intervention course, the DWI Victim Impact Panel, and the Community Alliance for Traffic Safety New Intervention Program. Is he already on a Smart Start mobile from pretrial? I'm guessing he is.
Yes, sir.
Let's continue to the Smart Start mobile at 4 blows a day. And I'll put him on partial GPS. He can go to work and he can go to these classes and, go to the grocery store and do any kind of required thing. Otherwise, he has to spend the night at home. Is that something that partial GPS would mean to the defense and the state?
The state only wanted 6 days. Can we just do full for 6 days instead of partial for 2 months? Because
Is he working?
He's not. He's
Okay.
retired. He had a very good long career that he's finished.
Okay with me. I mean, you just pick 6 days you want to use. You want to do weekends or something? I mean, you got 2 months, so you can plug your 6 days anytime in during the 2 months. I don't think the state cares.
No, I'll just let him work it out with probation, which 6 days he wants to pick. He'll have to get fitted with the GPS and then
That's
take it
it.
off right when those days are ready.
Okay, state, is that equitable to you? Is that something you can live with?
Correct, Judge, that's good.
And defense, is that okay with you?
Yeah, probably the most important thing is left is he's going to have an automatic driver's license suspension as a result of this conviction. If the court speaks to the term, DPS will go along with it. If you're silent, they'll do it for 2 years. Could you please order that it be suspended for 180 days, Judge?
Sure. Because it's, even whether it's a first or second, it's still a subsequent offense, I think, is how they look at it at DPS,
Correct.
right?
Correct.
Yes, Your Honor.
I'll order 180-day suspension if they don't order 2 years or something.
Thank you, Judge.
And as soon as he can legally get an occupational license, I'll be happy to give him an occupational license. Just don't get me in trouble with DPS. I'm already in trouble.
Yes, sir. Thank you.
All right. Hey, Mr. Allison, the ball's in your court. You got to finish these courses on time. The state has the ability still to file what's called a motion to revoke your probation. And that means you can still go to jail for 6 months. So we don't want to do that.
No, sir. I've tried to get into it, but they won't let me start until you guys make the order. So that's why, or I would have already been working on them.
I'll let Mr. Mulliner handle all those tricky details. He's the best lawyer I know.
Okay.
That problem will be gone now. So.
All right,
Thank
we
you.
good?
Yes, thanks, Alex. Thanks,
Good,
Your
Mr.
Honor.
Allison. Thank you, Mr. Mulliner.
Mr. Allison, and remember, 48 hours, if you haven't not heard from probation, you need to call. Do you have that phone number?
You said 210-235, and I didn't get the
No,
last.
it would be 210-335-4200. And ask for.
4200.
Okay. There you
Thank
go.
you.
Sorry for all the verbiage, Judge. Thank you, Your Honor. May I be excused?
You bet. Thank you. You can.
Thank you, Judge.
Okay. Here's another one that the state and the defense have gotten colorful on me on. Before we get into this on Mr. Villalobos, I've got in my notes that y'all are trying to do 60 days full GPS house arrest or something if he does these courses. Is that kind of where we're coming from?
No courses, Judge. Sorry, go ahead, Alexis.
No, what she's right. We got approval from our chief that we're gonna not do the classes and then just do the 60 days full GPS house arrest in lieu of 60 days Bear County jail.
All right. So we're not doing DWI, DWI, or DIP or CASNIP, correct?
Correct.
Correct.
And boom.
Judge, the only issue is that we were doing this for medical reasons. My client does have 2 medical appointments, one to the neurologist and one to another doctor. I just need to make sure that he'll be allowed to go to his medical appointments while he's on GPS.
Not a problem. I'm going to need a fine amount, I think. This is going to be a JSAT at the end of 60 days. Is that kind of where we're going with this?
Yes, Your Honor.
Okay. Let me try this and see if this works. In clause 631331, Mr. Villalobos, the court, or to the charge of, driving while intoxicated with a blood or breath alcohol content greater than 0.15. How do you plead, sir?
Judge,
No contest.
I'm sorry, Judge, they were going to reduce it to a straight DWI, according to Mr. Moreau. So the plea paperwork says straight DWI, not DWI with a blood alcohol of 0.15.
Let's try this. The court accepts your plea of no contest to the offense of driving while intoxicated with a blood or breath alcohol content 0.15 or higher. I find you guilty. I sentence you to 60 days in the Bear County jail. And for equivalent, due to your medical circumstances, we're going to make that 60 days full GPS house arrest with the understanding if you need to go to doctor's appointments and stuff, that is excluded, and you can certainly do that. Let's say a $500 fine plus court costs. And Rose, what else do we need to do?
Judge, because it is a sentence,
I mean,
are the time and money going to run concurrent? That's my question. I explained to him that they were. I presumed they were.
He only has one case, right?
Yes.
Okay. And I missed that last portion of what you said. I apologize. Say that again.
I'm sorry, Judge. I presume since it was an actual 60-day jail sentence that his time and money would run concurrent. And I didn't double check that with Alexis. But,
That's correct, Judge.
That's correct.
and my only other issue, Your Honor, is because it is a conviction and it's jail time, he will get a surcharge on his driver's license. He is not driving. I don't know that he'll ever be allowed to drive again, but I am asking the court, since he is indigent and I am appointed, if the court could recommend to DPS to waive his surcharge.
I thought they did away with the surcharge. Didn't the legislature do away with the surcharge?
They call it something different now. There's some term. I don't remember. I still call it a surcharge, but I
If
think
you
it's
find me a legal way to do away with it, the state won't object. You know, I mean, if he's indigent, that may be a legal way to do it. I don't know what, he's not indigent. I'm not going to lie for him. But on the other hand, find me a legal way the state won't object to, and we'll try to get around the surcharge. How's that?
perfect.
Thank
Thank you.
you.
Your Honor.
You?
Yes.
Okay. Because
My-
Alexis is a stickler for that, letter of the law thing. She's don't want to mess with Alexis.
It's good. The only question, Judge, is how does he go about, is there a time when he needs to go get his GPS? Since it's not probation, when do you need him to go in?
Basically, I'm going to give him time to report. I guess he needs to report to the jail would he report to get GPS put on? Does everybody agree? I mean, I'm not even sure.
That's my understanding.
Believe so.
It's Thursday now. We can do it
But
Monday
Your
or
Honor,
sometime.
you need to give, Monday. Monday, he should be able to Monday.
Okay.
I guess report Monday to the Bear County Jail. And if something comes up and he's got a medical problem or something, just give us a call and we'll make it a time and date. Basically, he's going to go to the jail. They're going to put GPS on him. They're going to release him and explain to him he can only go home. But if he's got any emergency stuff, I'm telling you on the record that he's welcome to go to medical appointments and any other emergency type problem he may have due to his medical circumstances and get in trouble for that. And at the end of the 60 days, boom, it's over. I guess that's how we're doing that. State, is that your understanding what you're trying to accomplish?
Yes.
Yes.
Okay.
Judge, does he need to come to the court to give his fingerprint?
I'm sorry?
Does he need to come down to your courtroom to do the fingerprint? No?
Not that I'm aware of. Not that
Okay.
I'm.
Just checking.
Okay, Mr. Villalobos, you're going to be our test subject, our guinea pig on how this is going to work. If you have a problem in any capacity, you call your attorney, she calls me, and we'll work it out, okay?
Thank you,
All
Your
right.
Honor.
Good luck, sir. Thanks a lot.
All right. Thank you, Judge. May I be excused?
Yes.
All right. Thank you, Alexis. Thank you, Pat.
Bye.
In clause 648-298, State of Texas versus Christian O. Venegas Orendane. Let's see.
Your Honor, Mr. Lopez had to leave. He had that other hearing. He will be back.
Okay, so we're going to wait for Ray. Put him on the back
Yes,
burner.
Your Honor, he had to leave.
Understand. Clause 635-493, State of Texas versus Matthew Grimm. State, you have a motion on this case, apparently.
Yes, the state moves to waive the enhancement and proceed as a DWI first.
No objection from the defense, that will be granted. Mr. Grimm, to the charge of driving while intoxicated, first offense that he pleads for.
No contest.
And is there an agreement for Mr. Grimm?
6/14, $300 fine, court costs, 36 hours community service, DWI education, DIP, PAT SNP, and Smart Start Mobile for half the term.
And Mr. Brandon Lopez, is that your understanding of the agreement?
It is, Your Honor.
Okay, Mr. Grimm, the court accepts your plea of no contest to the offense of driving while intoxicated, first offense. I find you guilty. I'm sorry. To the offense, yes, what it is, first offense. I find you guilty. I said 6 months in the Bear County Jail, probated for 14 months, a $300 fine plus court costs, 36 hours of community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program outpatient drug course, and Smart Start Mobile Home Interlock for 7 months. Anything further from the state of the defense of Mr. Grimm?
Your Honor, the only question was, he has some pre-trial conditions. Would those go away since the plea is calling for?
What do I have him on?
Judge, he was a day late getting his Smart Start mobile, so you had put the scram on him, and he's had it on for 2 days.
Does he have GPS also, or just scram?
Just scram, Your Honor.
Okay, we'll waive that, and I'll put that on the order going in, that all pretrial conditions are waived.
Thank you, Your Honor.
Thank you. Okay, so he needs to go back on the Smart Start Mobile, is that correct?
Yes, Your Honor.
So he's gonna have 10 days to come off of scram and go back on Smart Start. Will that work?
Yes, Judge.
All right.
Matthew, that works.
So I'm already on the
Oh,
Smart Start.
You're still on Smart Start? All right, then just turn in the scram and off we go. And you may have to get an order to do that. I'm not sure how picky they are about turning in all those things.
Okay, Judge, I'll follow it up. Thank you.
All right. Thank you, Mr. Graham. Good luck. Thank you, Mr. Lopez.
Thank you.
Thank you.
644082, State of Texas versus Destin Deaton. Mr. Deaton to the charge of unlawfully carrying a handgun. How do you plead, sir?
What is it? Non?
No contest, correct?
Yes, sir.
Court accepts the plea of no contest. State, is there an agreement on this case?
12 months deferred adjudication, $300 fine, court costs, motion to forfeit the weapon, and a gun safety course.
Your Honor, that does reflect our agreement. However, I did file a motion for the court to award the weapon to me.
And what kind of, I know it's a handgun. What kind of handgun is it?
It's a Glock, a 22 Glock.
Okay. State, I'm going to deny in the nicest possible way your motion to destroy the weapon and award it to the defense counsel as attorney's fees with the understanding it will not be returned to the defendant, his family, or his friend. That agreed?
That was stipulated in the order, Your Honor.
There you go. Okay. And otherwise, is that your understanding of the agreement?
Yes, Your Honor.
Right.
And the firearm safety course thing. Mr. Deaton, in cause 644082, the court accepts your plea of no contest. The defense of unlawfully carrying a handgun, although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt, place you on 1 year deferred adjudication probation. It says a $300 fine plus court costs, and order you to go to a firearm safety course. And the VTC has a specific firearm safety course in mind when we do this that we can get. Find out the exact name of it, the phone number for you all to contact. State's motion to destroy the weapon is denied in the nicest possible way. Weapon is hereby awarded to defense counsel with additional attorney's fees, not to be returned to the defendant, his family, or his friends, and the defense has agreed to that. Anything further from the state of the defense of Mr. Deaton?
No, Your Honor, we rest.
Good luck, Mr. Deaton. Thank you, Mr. Hernandez.
Mr. Deaton, you know to go to probation, that they're going to contact you within 48 hours, right?
I tried writing down two numbers y'all said.
Okay, it's 210-335-7200. Okay, and ask for intake if they don't contact you.
Yes, ma'am. In 48 hours?
Huh?
48 hours?
Yeah, if they don't within 48 hours, you call them.
Yes, ma'am. Thank you.
Mr.
Thank
Deaton, if you
you.
have any questions or concerns, feel free to call me as well.
Alrighty. Thank you.
Okay, y'all dismissed. Thank you.
Thank you, Judge.
We ready to go back on for Johnny Angel Hernandez and Mr. Finch?
Yes.
Yes, sir, I'm here.
Yes, Judge.
Okay, we got combo squared away. Great, thanks. Let's start over. Clause 634827, State of Texas versus Johnny Angel Hernandez. Mr. Hernandez, I am looking at a document entitled Defendant's Consent to Plea by Video Conference that purports to have your signature and your attorney's signature on it. Is this your signature on this document, sir?
Yes, sir.
And Mr. Finch, as attorney for Mr. Hernandez, is this your signature on this document, sir?
Yes, Judge.
Thank you. Mr. Hernandez, the next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonition that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, sir, is this your signature on this document?
Yes, sir.
Thank you. By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, Mr. Finch, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Yes, sir.
Thank you. Mr. Finch, as attorney for Mr. Hernandez, have you had enough time to go over this case with him, and in your opinion, is he mentally competent?
I have, Your Honor, and he is.
Mr. Hernandez, are you a United States citizen, sir?
Yes, sir.
Okay, and Mr. Finch, has the state fully complied with discovery for you on this case?
They have, Judge.
And state, you apparently have a motion on this case also, do you not?
Correct, Judge. The state moves to waive the enhancement and proceed as a DWI first.
No objections, Judge.
And no objection from the defense, that will be granted. Mr. Hernandez, to the charge of driving while intoxicated, first offense, how do you plead, sir?
No content.
Is there an agreement for Mr. Hernandez?
6 over 12, $500 fine, court costs, 48 hours community service, DWI education.
Also, if I could, the judge, that's not the agreement. We had been offered a 14 months deferred offer with a $500 probated fine. I don't know if it was Alexis made the offer or Nick made the offer, but we'd kind of gone back and forth, and we had conferred about that on the 9th. I don't know.
It was Nick. Since it's an odd case, it was probably Nick.
Okay, Judge.
Yeah, that was my case, Mr. Finch. When
Okay.
did we discuss that?
We got recalled on the 9th.
Was it an email or was it you and I just talking in a breakout room?
I think it was you and I in a breakout room at that point.
All right, yeah, I remember that. Okay, was it 14 months?
Correct. And a $500 probated fine, 48 hours community service, then the bells and whistles.
Yeah, that I remember that. Sorry about that, Alexis. Yeah, that's correct.
Okay with me. Okay with you guys. Let me try to run through it and everybody make sure I'm on the money here. Okay, Mr. Hernandez, the court accepts your plea of no contest to the offense of driving while intoxicated. First offense, I find you guilty. I'm sorry. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 14 months deferred adjudication probation. Assessing a $500 fine, probating all that plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, and Smart Start Mobile Home Interlock for 6 months. Mr. Finch, is that correct?
That is, Your Honor. Thank you sorry for the confusion there.
And Mr. Maru, is that correct? We need to blame it on somebody. We'll blame it on Nick.
Yes, Judge. Yes, Judge. You can blame it on me. That's fine. That is correct, Judge.
I'll take all responsibility, Judge. Sorry for that.
All right. Anything further from the state of the defense on Mr. Hernandez?
No, Judge.
No, Your Honor.
Thank your lawyer, Mr. Hernandez. You got you a sweetheart deal. You can see the other DA is going to beat up this DA when this is all over. Y'all are dismissed. Thanks for your help.
Thank you,
Okay,
Judge.
Mr. Hernandez, you have the phone number for probation?
Yes, ma'am. I wrote it down.
Thank you.
Good luck. Mr. Hernandez, be in touch. Good luck with everything.
All right. Thank you, sir.
Okay, so now we're just waiting for Ray Lopez to get away from his other hearing.
Yes, Your Honor. Mr. Anders, do you have something you want to talk to the judge about?
I was just looking to get, Your Honor, I was looking to get a date set for that restitution hearing.
Okay.
I'm open all
Wednesday
next week.
morning? A Wednesday morning, Your Honor?
Okay, here's the deal. There is no restitution right now, right? Nobody's telling him to pay any money to anybody, right?
Well, the court has made the statement that to pay restitution as to be determined.
If any, right?
Yes, but the issue lies with the idea that the courts have basically stated that that the trial court cannot delegate this authority to probation officers. And so based on that, the idea that the court say, if any, means that the probation officer is doing research and trying to find and later on trying to come up with some sort of restitution amount. And so my position is that if we're to make a clear and clean, and like you had mentioned earlier, without letting things drag out, a decision and sentence on this particular person, that restitution needs to be either determined at the time of the actual sentence, or a restitution hearing be set in short order so that restitution could be determined, if any.
Judge, if I may.
Sure.
Mr. Honors, I'm not sure. You and I haven't conferred about this case, and so I'm just going to jump in here.
Sure.
If this was the case, it sounds like there was open, not really open per se, but this doesn't really sound like an agreement to me. If this is the case, what we can do is we can take back the plea, set this for trial until we do figure out restitution. I understand what you're trying to do here, and I it's admirable, but at the same time, this is how pretty much all county courts operate. I understand you have case law, and I would love to see that case law. But what I will say is that, and from my experience, when we put restitution, if any, when they send those letters out, no one responds, which means your client more than likely is going to end up paying nothing. However, if you have us determine this, I'm going to make this my full-time job now to go to this individual's home and knock on their door to determine what the amount is. And then he might actually have to pay something. So, I mean, I understand what you're doing, and I would love to see the case law because I'm always trying to, expand my book on this too. But this is not out of the ordinary. We do this quite often.
Okay, sir, I just wanted to make sure that the court reporter was taking down what the ADA was saying, that he would take a special interest in this case if I were to defy what he believes the entire court system, as far as Bexar County county courts, have been doing. And if that's the case, I wouldn't mind talking to him, because there's something needs to be done. It needs to be brought to the attention of an administrative judge, because we're doing it improperly.
Well, sir,
according to
your point,
sir,
isn't your whole point for me to determine restitution? But now you have a problem with me going to the person's house to determine restitution. I'm trying to figure out what you want here, sir.
What I'd like is
restitution, then I'm going to go to their house and knock on their door. I mean,
what I'd like is a restitution hearing in short order. That's it. So a restitution hearing next week on Wednesday. Knock on his door all weekend if you want to, and we'll have it on Wednesday.
Mr. Anders, time out. Everybody stop talking. I'll be happy to let you talk as long as you want after we chat here a little bit. Back on the record on 651-436, State of Texas versus my Sean Montgomery. And for the record, I know nothing about this case. I don't know Mr. Montgomery. I barely know Mr. Anders. And of course, I got to see Mr. Maru a lot more than I ever wanted to, but you know how that works. So there you go. What we've been doing for the last 18 and a half years, whenever there's an accident on a DWI case, I think the state, as Mr. Anders will probably represent, assumes automatically that it's the defendant's fault that he had caused an accident because he was intoxicated. That's not always true. I think we can all agree, probably. I have no idea what's true or not true in this case. I know no facts. I don't know anything about it. Mr. Anders, can you give me some insight into how aggravated or not aggravated this accident was?
My understanding was that it's a fender bender. The person has contacted the equivalent of a Thomas J. Henry to move forward with his particulars of the case against an insurance company. The difficulty that I have is that apparently the ADA has attempted to get a hold of him and he hasn't been responding. And the reason why is probably because he has an attorney that they're trying to get yada, 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 right? But Your Honor, just to the argument of for 18 years of doing this, I mean, the same argument could be made pre-Civil War, right? For years and years and years, we've had slaves. Why are we changing? And so that's the same argument for years and years and years.
Okay.
We've done it this way, but why should we change? And my response to that is Ortega v. State says that judges, unfortunately, the courts cannot delegate its authority for this type of activity. Because it specifically says the trial court may not delegate this authority to the probation officer or anyone else.
Here's how it works, and I agree with you, but here's how it works. I utilize the probation department to go do an investigation. This DA is not involved unless the DA wants to be involved. It's strictly the probation officer that's assigned to Mr. Montgomery on this case, and they would normally not do anything other than send a letter to the alleged victim on the accident and ask if they're asking for restitution. And if the letter comes back and says, yes, we're asking for restitution, then we get back to you and we say they're asking for restitution. Do we know if Mr. Montgomery had active insurance at the time?
I believe he did.
He did? Okay, well, I mean, that's probably going to take care of it. If it doesn't, then you get your hearing for as long as you want, any way you want. But if you look at it from our standpoint, from the criminal justice system standpoint, what we're really looking at is kind of a civil issue more than a criminal issue, but it would take lots of witnesses and lots of time and basically a lot longer than it took us to resolve this case for me to get enough evidence in front of me to say this person was the proximate cause of the accident, or it's 40% on this side and 60% on that side. And we normally, I bet there's probably an 80% chance conservatively that they're not even going to ask for restitution. But that's just our experience of doing this.
So Judge, let me ask this. Why do we have trials if they're such a big pain in the ass and all we really need is just to have the police officer come in and tell his story, and then we can make a decision at that point in time? It's the same concept. And the reality is that I understand your statement that yes, you use the probation office for certain things, and this doesn't have anything to do with the assistant district attorney, which is fine. I don't have an issue with, you know, Miss O'Connor and Mr. Nicholas. I'm not familiar how to say his last name, but I don't have an issue with them. What I have an issue with is the idea that the court is delegating its authority to the probation department, and the law as determined, as translated, I can't remember the specific word for it, but right now the law states that the court does not have that authority. It doesn't have the authority to delegate that to the probation department. And so what I'm saying is that, and that's why I said I'm happy to share this case and whatever law I have with whoever wants to see it. But that's just the simple reality of it, is that the way that it's supposed to happen, and Bear County, I can talk to you about Bear County doing things one way and the way it's supposed to happen being another way, because that I've run into that a lot when I venture outside of Bear County. But the situation really is that it's supposed to happen in the following manner. It's determined either before or at the time of sentencing, or a hearing is set at sentencing for a time period to be able to make the determination about restitution. And there's no reason that should be, 12 months from now. It should be Judge, 1 week from now.
Judge, if I may, real quick.
Sure.
And Mr. Anders, you jump in anytime, correct me if I'm wrong. Alexis, did Mr. Anders ever send you this case law?
No, I don't think so.
Okay, so this is the first we're hearing of this case law. So I would like to review it. I mean, if you sent it, Mr. Anders. So I believe you if you say you did.
Well, I made mention of it, and then the response was, basically, 2 fingers and set it for trial if you don't like it.
Well, I don't think anyone, I think it's a little dramatic. I don't think anyone said
it was dramatic, yeah.
It was dramatic? Okay.
Yeah, what I said was dramatic, yeah.
Okay. So what I'm going to go ahead and recommend to help everyone, so we get what we, because, this is turning into 2 dogs peeing on a bush at this point. What I'm going to go ahead and recommend is that we take away the offer, we set it for trial. We determine restitution. I read your case law, and we go from there. And you have my word. The offer will remain as is. I'm not going to jack up terms, jack up anything, nothing like that. To get what you want, we'll determine the restitution. If we can't figure it out, we'll set it for this plea. We'll retake the plea, and there won't be any restitution. And in that way, everyone gets what they want.
Okay, so this will happen next week?
Yes, sir. Provide me with that case law. I'll go over the case law, and we'll go from there. We can set
so
this.
Next week we'll have our restitution hearing.
No, sir. That's not what I'm saying. If I determine that I can get a hold of anyone, because there's no point in having a restitution hearing if I can't even call in a witness to say what happened, right?
That's what
I'm saying is what we'll do is we'll reset this for plea next Thursday. Okay. If by next Thursday I have not gotten a hold of the victim, we have nothing, then there will be no restitution placed down whatsoever on the agreement.
So you're going to file a motion for new trial. Is that what you're saying?
Yes, we can do that.
If there's a good reason why you're doing that, my understanding was that the judge said that this has nothing to do with the assistant district attorney's office.
What do you mean this has nothing to do with it? I got a word from my chief because I heard this all going on. So I went on mute and I called my chief, and she told me, you need to personally reach out to that victim. You need to write a letter. And if not, if they're really being dead set on it, you can stop by their house and you can knock on the door, which is why I also take exception to you noting for the record that I'm going to take a personal whatever you said in this case. If what you're asking for is for me to determine restitution, that is what I will do. I am here to serve, Mr. Anders. So if you're asking me to determine restitution, I will determine restitution. Does that work for everyone?
The judge, the agreement's already been set. It's already been made. I'm asking for a restitution hearing according to law. And now the assistant district attorney's office saying, well, if that's the way that it's going to be, since you're bucking the system or bucking whatever it is that I'm bucking, that now they need to file a motion for new trial so that we can determine restitution, but keep it on the trial docket.
Okay, Mr. Anders, I apologize for interrupting. It's time for judge stuff. In cause 651-436, State of Texas versus Marshawn Montgomery, the plea has already been made. The plea bargain has already been agreed to by both sides. The only issue that the defense is objecting to at this point that I'm aware of is the fact that both the state and the defense entered into an agreement that it was the defense could go open to the judge without a recommendation by the state on the question of restitution. You did that. I ruled as of right now, there is no restitution in this case. There's probably a high probability there will never be restitution in this case. I don't know anything about this case. So what's going to happen is, and if you want Mr. Maru to do this, all you have to do is ask him and he'll do it. But there's no need for the state to investigate restitution. The probation department will do that in a normal course of business. And it'll probably benefit the defense the longer this goes on to whenever they get up with the victim, if they get up with the victim. Now, defense, if you want to expedite that, Mr. Maru is just that he represented to you, will be happy to acquiesce to your request, and he will personally contact the alleged victims, and he will make a personal determination, not my determination, not your determination, of what he thinks restitution, if any, is due, and let you know about that. That's between you and Mr. Maru. It's not my problem. But at this point in time, we're not going to have a restitution hearing. Please provide your law that you are going to provide us both to the court and to the state, and give us about a week to look at it. And if you're right, then we'll be the first ones to say, you're right, you got us. We've been doing it wrong for 18 years.
Yes, sir.
I'm excited about that.
Mr. Maru, do you agree with that?
100% agree with that.
All right. So at this point in time, we're done. Mr. Montgomery got a great deal. If, as, and when restitution becomes an issue, we're going to have a hearing. And whenever Mr. Anders wants to have it, that the state is convenient for the state and they can get their witnesses up, and whatever else you all want to do is fine with me. Fair enough, Mr. Anders?
Okay.
Okay.
Nick, you want me to, I think I have your address, your email address.
Yes, sir. If you could just shoot me that case law, I really appreciate
Awesome.
it. Thank you.
I can. And how do I send it to the court?
Send it to Pat, which
Send
is
it to me. Send it to me, Mr. Anders. I'll get it.
Okay. Thank you very much.
all right. Best of luck. Thanks, guys.
Good argument, James.
Okay, Mr. Lopez, welcome back.
Y'all
Glad I
can't
could
hate,
be back, Judge, to catch that.
yeah, y'all can't hate me much. Nick and Alex, sorry about that confusion earlier. Yeah, I've known Judge. I have heard of that case law. That's all I'm saying.
Hey, the record reflects that Mr. Finch was laughing all through the conversation for the last 20 minutes.
I was only smiling because I was on mute, Judge. Yeah. Y'all have a good afternoon. Yeah.
All right, thanks, Matthew. All right, back on the record on 648-298, State of Texas versus Christian O. Benegas Orendane. And bring me back to where we were. I think we were basically to the point where he had to enter a plea or something. Is that kind of where we're at?
Yes,
We've already gone over the preliminaries.
I had to leave for a
Right.
hearing, the pretrial hearing in another matter.
Okay. So, Mr. Benegas Orendane, in clause 648-298, to the charge of unlawfully carrying a weapon, how do you plead, sir?
No contest.
An agreement for Mr. Benegas Orendane.
6 months deferred adjudication, $300 fine, court costs, 48 hours community service, motion to forfeit the weapon, and a gun safety course.
And this is a handgun. I mean, what kind of handgun is it, Mr. Lopez?
I'm not sure, Judge. I'm sure he could be able to tell us.
Hey,
It's
Mr.
a Glock 23C, sir.
It's a what again? Glock 22?
23
Glock
C.
23. 23C, sir.
Okay, I apologize. I'm having a hard time understanding what you're saying about what kind of gun it is.
He said a Glock 23C, Judge.
23, okay. What I normally do in these cases, because I don't want to destroy a quality handgun, that's certainly a quality handgun, is award it to the defense counsel as additional attorney's fees with the understanding it's not to be returned to the defendant, his family, or his friends. Would that be acceptable to the defense?
Yes, Judge.
And state, would that be acceptable to you?
Yes, Judge.
Okay. Mr. Benegas Orndane, the court accepts your plea of no contest to the offense of unlawfully carrying a handgun. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 6 months deferred adjudication probation. It says a $300 fine plus court costs, 48 hours community service. State motion to destroy the weapon is respectfully denied. The weapon is hereby awarded to defense counsel as additional attorney's fees with the understanding it's not to be returned to the defendant, his family, or his friends, and the defendant shall complete a firearms safety course. Mr. Ron Mora with the Bexar County Veterans Treatment Court has the name and number of the safety course that we use. And if you either call Pat or call him directly, we'll get you that information so you know what kind of course to go to on that. Anything further from the state of the defense on Mr. Benegas Orndane?
Nothing from the defense, Judge.
Okay. Thank you, Mr. Benegas Orndane. You've been very patient. We've kept you around here all day.